A Crash Course in Copyright, Part 1, The Basics. I'm Christy Padrone. I'm the Scholarly Communication Librarian at the Florida Atlantic University Libraries. The subtitle for this presentation is Copyright Basics for Anyone Who Creates. The three learning outcomes for this presentation will be: first, to discern the benefits of knowing about intellectual property; second, define copyright and its rights and protections for creators; and third, identify copyright infringement and its consequences. If you'd like to test your copyright know-how, take the pre-test at the URL or use the QR code to go to the quiz. We have 5 quick questions that you won't be formally graded, and keep the questions in mind because we will get answers for them. If you'd like, feel free to pause this presentation to take the little quiz. Disclaimer: the FAU Libraries and its faculty, staff, and administration are not attorneys and cannot interpret the law. And this information is provided for educational purposes only and does not substitute for advice from legal counsel. Copyright frequently makes the news with high-profile court cases that seek damages. In the illustration you see, you've got Drake. He won a fair use case where he used a song that sampled some jazz music from somebody in the 80s. The family of the musician, who is now deceased, had sued Drake, claiming that his use of the song was copyright infringement. Another high-profile court case was between Google and Oracle, which made it to the Supreme Court. Oracle had asserted that Google infringed on its copyright for Java. Then in the third example, where you see the 2 people with the puppies, an artist took an image found on a greeting card and then made some changes to it. The photographer of the original work that you see on the left in black and white had sued Jeff Koons, the artist. They eventually settled out of court. Since we have scenarios that use different types of work, copyright applies to many types of creations and intellectual property, ranging from music, lyrics, computer code, and art. What is intellectual property? The World Intellectual Property Organization defines them as creations from mind. They can be inventions, literary and artistic works, designs, symbols, names, and images used for business. Intellectual property, or IP for short, is protected by law throughout the world. There are 3 types of intellectual property. The first are patents, which are an exclusive right granted for an invention. The second type is trademark, which is a sign that identifies a company, good, or service from those of another. The third is copyright, or the rights granted to creators over their tangible literary or artistic works. This presentation will focus on copyright. I'm a college student, I'm often told, so why should I understand intellectual property or copyright? Borrowing from the former late-night show host David Letterman's top 10 reasons for things, here are my top 5 reasons to understand intellectual property. First, if you make things, then you are a creator. This is whether you are a student or a faculty member, instructor, or just in the general public. If you create, then you probably have copyright for your work. We'll discuss what this means a little later. Third, you often reuse some of or build on the work of others for your college and eventually your professional life. Fourth, you are more likely to respect intellectual property, yours and the work of others, and reuse it in ethical and legal ways if needed. Finally, it's important to know your rights. You can benefit, profit, or just feel good from your work and your creations. Copyright defined. The U.S. Copyright Office defines it as legal protections and rights for creators who make an original work in a fixed medium. When I explain copyright, I like to emphasize certain phrases within the definition. The first phrase is an original work. So what can get protection? Literary works, such as poetry, books, articles, and even computer code, which the courts consider textual works, can get copyright protection. So can musical works, whether they are lyrics, compositions, or the voice. Dramatic works, such as plays, can get copyright protection, and also pantomimes and choreographic works. Pictorial and graphic works, such as images, photographs, or graphic arts, can get copyright protection, and so can cultural works such as designs, dances, or songs that are indicative of a certain cultural group. Motion pictures and other audio works can get copyright protection, so full feature movies as well as short takes and clips can also be copyright protected. Sound recordings can get copyright protection, and so can architectural works. The second part of the definition is fixed medium. It is defined as a work in a tangible and permanent form. Intangible things cannot get a copyright, and neither can these, such as ideas on their own, or recipes, measurements, facts, processes, as well as principles and discoveries. The third part of the copyright definition are rights for creators. Copyright law defines what creators can do with their work. They can reproduce it or make copies, and also distribute or give the copies away or sell them. They can prepare derivative works. If I wrote a book, I then could write a screenplay, which is considered a derivative work of my initial book. A creator can also display their work publicly and perform it. And for sound recordings, creators can perform the work publicly using digital means of transmission, like going on Pandora or YouTube. Copyright defined, protection and time. Copyright protection is provided for a length of time and depends on the following factors. The format of the work. Is it a book, image, music, sound recording, or other type of work? The year of its creation. The length of copyright protection depends on when a particular work was created. Country is another determination, or where a creator was when they made the work. These can be determined by looking at copyright law, some authoritative web pages, see our references at the end of this presentation, and at a work's copyright statement. There is no rule of thumb in terms of copyright protection. Refer to current copyright sources. Copyright protection depends on when a work was made. However, here are the current terms for frequent works. For works made before 1926, they are in the public domain. They do not get copyright protection. Works made after 2002 have varying terms depending on whether the copyright is held by an individual or a corporation. For an individual, it is 70 years after the creator's death, meaning that a person has the copyright for as long as they live, plus 70 years. And when a corporate organization holds a copyright, it would be 95 years from the publication or 120 years from creation, whichever expires first. In the U.S., sound recordings published after March 1st, 1989 have similar protections as works made after 2002. Architectural works made from December 1st, 1990 also have the similar protections as current copyright terms. Test your know-how. Let's think about a couple scenarios based on what we've heard so far about copyright and see what you think. For the first scenario, Sammy's student just finished multiple tracks of his self-produced recorded music. He's not sure what copyright protection would do. What would you tell Sammy? Second, how long will Sammy have the copyright for the recorded music he made this year? Next, we'll talk about copyright infringement. Copyright infringement is defined as taking on the rights of a copyright holder when you do not have them. Here are some examples when you don't have copyright for a work or permission to do the following. Copy and distributing. So let's say you make multiple copies of Jean-Michel Basquiat's artwork and give them all away. That probably would not be allowed if you did not get permission from his estate. Making derivatives. Publishing a guide to the characters and seasons from The Walking Dead when you don't have permission would be considered copyright infringement. Selling, that is, ripping and selling bootleg DVD copies of a streaming version of a play or a movie would be considered copyright infringement. Displaying a work without permission and when you're not the artist would also be considered copyright infringement. And finally, performance. So let's say your band plays Radiohead's music in a public venue without getting the performance rights to do it. Copyright infringement is both a legal and an ethical issue. Taking or using property of others without permission is similar to copyright infringement. Kind of like in the case of the greeting card picture with the puppies that was then used to be something different. It's also having works be used without permission, and owners miss out on the benefits of the work, whether it's esteem or rewards for their efforts or even profit. However, debates are abound about intellectual property. They may range about who owns what about if something that was created or information or works are for the public good and more people should be allowed to use them without permission is another debate. Then there's always the blurred line of creativity and inspiration, especially when your ideas build off on another. And then there's the whole aspect of convenience. Copyright infringement may occur because someone considers it inconvenient to ask for permission to reuse the work. The law can inform us and we can try to apply copyright in good faith. However, keep in mind that courts make the ultimate decision about infringement. Copyright infringement consequences. Current copyright law is defined in United States Code Title 17, and infringement is United States Code Title 17, Section 501, called infringement of copyright. The consequences seem to have a step-like action. First, you may get a takedown notice. You will be asked to stop reusing a copyrighted work, or maybe take it off a web page, or stop distributing it from the copyright holder. The second step may be a civil action. Perhaps impounding may take place. This is to gather the infringed works and turn them over, or they can be destroyed. There may be a lawsuit for damages. Statutory damages means that a copyright owner can sue to recover damages if they think they have lost income or otherwise the demand for their work lessened because of the infringement. Lawsuits may also include costs and attorney fees. At this time in October 2021, Copyright Small Claims Court, or CASE, is being created. The idea is that instead of going to a court, copyright cases would go to like a small claims court that focus on copyright only. More information about this is to be announced. A final consequence of copyright infringement could be criminal proceedings within 5 years of the infringement. This can take place if infringement is done for profit or commercial advantage with a retail value of over $1,000. Criminal proceedings can also take place if there's a fraudulent copyright notice or when someone willfully claims a copyrighted work as one's own. An example I could provide for the first part about infringement done for profit or commercial advantage is when I was overseas, I noticed a street corner vendor had a lot of DVDs with case covers that you can tell were copied. This person had ripped a lot of copies of full-feature movies and was selling them on the street. So our advice to you on copyright is to be informed. Ideas really do build on the ideas and works of others. However, copyright does confuse or frighten many, and the answers to copyright matters typically begin with, "It depends." We recommend to use authoritative information sources or seek help when you consider using the work of others. But also at the same time, don't let copyright's complexity scare you from knowing and using your rights over your work and the rights you have with works protected by copyright. For more copyright information, visit the FAU Library's Copyright Research Guide at this URL. Topics discussed on this guide include Creative Commons, which are licenses that allow you to reuse copyrighted works when you follow specific conditions. Other topics include public domain, fair use, and work made for hire. This guide also includes a page on copyright law and exceptions. For those of you who are instructors, we also have the Copyright for Teaching and Learning Research Guide that discusses copyright from a teaching context. You can find authoritative copyright information at the U.S. Copyright Office. The webpage provides current copyright law, and then it has circulars that explain various topics. This page also includes ways to register your work so you can have legal documentation that your work is copyrighted. The Cornell University Libraries has a page, Copyright Term in Public Domain in the United States. That can help you determine if a particular work is in the public domain. Since we are a library, we do have some recent books about copyright. The NOLO Legal series has some really good books. Copyright Handbook is one that we have, and the public domain. But of course you can look in the library catalog for more titles that may be available. If you need help, visit our library homepage at library.fau.edu. You can reach us through text, chat, or email through our Ask a Librarian service. You can also request a consultation or a presentation if you'd like assistance with copyright, or you can contact your campus library or a library department. For those of you who are doing this for extra credit or an assignment, you can take the 5-item copyright quiz at this URL or by using the QR code. Results will be sent to you within a few minutes. A certificate is sent for answering 4 out of 5 questions for 80%. Thank you for viewing a crash course in copyright, Part 1, The Basics. I'm Christy Padron, the Scholarly Communication Librarian. Please let us know if you have any questions or want to make a request. Thank you.